Welcome to today's program, Judicial Nominations in 2011. I'm Caroline Frederickson. I'm the Executive Director of the American Constitution Society for Law and Policy. And for those of you who are not familiar with ACS, we are a network of lawyers, judges, policymakers, law professors, and law students that promotes the vitality of our Constitution and its fundamental values, individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. ACS has worked to draw attention to the federal judicial vacancy crisis. The Senate confirmed only 62 of President Barack Obama's judicial nominees in the past 2 years, compared to 100 for George W. Bush and 128 for Bill Clinton during the first 2 years of their presidencies. We have 875 federal judgeships, and we now have 101 vacancies. That's an extraordinarily high number. 49 of those vacancies are described as judicial emergencies. Most recently, the tragic death of Judge John Roll brought attention to this crisis. He was at the Safeway in Tucson to talk with Gabby Giffords about this very issue, about judicial vacancies in Arizona. And his death has resulted in Arizona now being added to the list of judicial emergencies. This vacancy crisis is obviously not a partisan issue. It's an issue about the integrity of our courts and the administration of justice for the American people. On the heels of Justice Anthony Kennedy calling attention to this problem, a group of Ninth Circuit judges, led by Chief Judge Alec Kaczynski, a Reagan appointee, wrote to Senators Reid and McConnell, urging them strongly to fill the vacancies. And Chief Justice Roberts highlighted this crisis in his year-end State of the Judiciary report. So what can be done about this? Well, today we are extremely lucky to be able to hear from someone who is so well suited to answer that question. White House Counsel Bob Bauer will share his views on the nominations process and what he sees as the likely developments in the coming year. Bob was named White House Counsel in November of 2009. He was formerly a partner at Perkins Coie and chair of its political law group. Bob was President Obama's personal attorney and general counsel of the Obama for America campaign. He also served as general counsel to the DNC, as co-counsel to the New Hampshire State Senate in the trial of Chief Justice David Brock. He was general counsel to Bill Bradley for president, and he was also counsel to the Democratic leader in the trial of President William Jefferson Clinton. Bob has graciously agreed to take a few minutes of questions at the conclusion of his remarks, and we will then hear from an extremely distinguished panel. So now it is my pleasure to turn this over to Bob Bauer. Thank you, Bob.
Thank you, Caroline. Good to see you. Thank you for your invitation to speak here today on the Obama administration and judicial nominations in 2011. I have been fortunately free to make of this topic what I would. My hosts kindly did not specify that I take any particular approach to the topic. So this then is what I propose to do. I would like to lay out what I hope that we can accomplish this year in cooperation with the Senate against the history of the last 2 years' experience with judicial nominations. What I will not do is rehearse the familiar litany of complaints about the nominations and confirmations process. There is plentiful commentary on the subject, some of which is learned and useful, and some part of which is the now dreary exchange of accusations about who has been behaving badly, or my favorite, the charge that someone behaved badly first, this apparently being enough to lessen the culpability of the person who behaved badly second. But the facts speak for themselves, and there's no need for rhetorical embroidery. Here are the essential facts, and as those of you who like to participate in sports debates say, you can look it up. The confirmation rate is perilously low, and one result is the large number of seats designated as judicial emergencies. More than one-half of the nominations now pending in the Senate are judicial emergencies, the state of emergency being that which, by the standards of the Judicial Conference, involves courts where the cases filed exceed the capacity to hear them. The vacancy rate overall has come to hover around a historic 12%. This is twice the more or less structural rate, twice the 5% rate that we might expect in the normal course of resignations, retirements, deaths. And yet we have nominees who have waited for historically long periods of time for a vote. There are now a total of 49 nominees before the Senate, nominated in the last Congress and now renominated or nominated for the first time just last week. Now, the Chief Justice of the United States, as Caroline pointed out just a minute ago, has taken appropriate note, correctly stating that the underlying problem has persisted for many years and that the need to address it has become, in his words, urgent. This chief is the second to take up the call against the breakdown in the nominations and confirmations process. Chief Justice Rehnquist did the same some years before, and for him, as he stated it, the consequence was a growing, unattended judicial workload and the threat that it presented of an erosion in the quality of justice. And over time, these concerns have also been registered by a range of task forces and special commissions, like the Miller Commission in 1996, which opened its report by stating, quote, "The federal judicial system continues to be plagued by a troubling accretion of unfilled vacancies, delays in the appointment process, and backlogs of pending appointments." Now, the effect of this judicial emergency, the state of judicial emergency, is predictable and it is pernicious. A massive backlog of cases causing egregious delays for Americans seeking their day in court around the country. Trials are delayed for months. Some courts lacking the necessary capacity have had to outsource portions of their caseload to other courts. And individual judges on courts with numerous vacancies have had to take on hundreds and sometimes more than 1,000 additional filings. What is most striking, what is most disturbing about this state of affairs is what I will call the general absence in the political sphere of the same sense of urgency expressed by the Chief Justices. There are exceptions, to be sure. Senator Leahy, the chairman of the Judiciary Committee, has spoken forcefully and eloquently to this problem, and his concerns are certainly actively shared by the Democratic leadership. But I have noticed in recent months, in the course of my conversations with members, that this concern is spreading, and it is by no means limited to one side of the aisle. Republicans, as well as Democrats, increasingly acknowledge, some privately, some publicly, that we are witnessing something profoundly troubling. Now, it is true, as many have pointed out, that there are institutional and structural explanations for the woefully inadequate pace of confirmations. For example, the Senate rules, for all practical purposes, permit a single senator to freeze the process for a particular nominee and a particular nomination. We are all familiar with the laments about the procedural tools that are available to accomplish delay, or the means by which delay becomes the functional equivalent of fatal opposition. These are all important points in a discussion of the confirmation process, but they are significant largely as expressions of the problem, not its primary source. The problem, as I see it, is at once more subtle and more profound. It is the very climate now enveloping the confirmation process, a climate many years in the making, in which it is widely accepted that this is the way things go, and that the costs cited by the chiefs, heavy costs, are somehow bearable. Now, distinguish this climate from the charged one of highly contested individual nominations. In the latter, we see proponents and opponents claiming that large consequences will follow from confirming or rejecting particular nominees. This type of conflict is far from the subdued setting for the confirmation struggles of today. If it is a war, and that's a trope I don't much care for, it is a cold and not a hot war. There are two examples of today's broader climate and how it manifests itself that may be useful. First, nominees left to languish on the floor for as much as hundreds of days without a vote are basically ignored, not put to one side because of perceived deficiencies in their records or shortcomings as potential jurists. It is a quiet blow to the process but it's a heavy blow nonetheless. No shouting on the floor, just nothing on the floor. It is as if, and it is apparently to some, as if it did not matter at all. But of course, it matters a great deal to the nominees, to the courts to which they were nominated to serve, and to the parties before those courts. Chief Justice Rehnquist quite rightly pointed to the grave loss in the quality of justice when we don't have enough judges for the cases to be decided. And it is a loss in the quality of justice when this very proposition, the proposition that we urgently need judges to have an effective and responsive judiciary, draws a limited or intermittently attentive audience. That's one problem. Let me cite another. In our selection of potential nominees and in consultation with senators and in some cases representatives, we have been forced to give up on qualified candidates in part because the opposition has been expressed as a concern about quality or qualifications. But in my experience, these concerns, however strongly expressed, are all too often hard to really pin down. Sometimes it's just a question of personal preference. The president has selected a candidate for nomination, and a particular member would have chosen differently. And this stalls progress on filling the vacancy. And if it stalls, well, it stalls because it seems somehow the delay does not matter as it should. This is a new world. A confirmation process once characterized by hard-fought battles waged around specific nominees is now disabled by steady resistance to moving nominees as a class across the board. This can happen, and it can only continue if its effects are seen somehow not to matter very much or not to matter enough. And yes, each party can always suspect the other of partisanship, of simply cutting back on one party's number of successful nominations, even where there is no great divide in any one case over competence or ideology. But this is the point, is it not? That if this is acceptable, even in the absence of major disagreements about competence or ideology, if it is okay to keep the court short of the judges needed to administer justice, then this only goes to show how the costs have become bearable and how the loss in the quality of justice somehow has come to seem not to matter. One question raised from time to time is whether this administration can do more to elevate the issue, to call more attention to this grave problem from varying directions and in varying ways. Be assured that we have made, and we will continue to make this case, as the President did forcefully in his letter to Congress last October. There he highlighted what he called the dramatic shift in the confirmation process, a change he noted that could produce, and I quote, a crisis in the judiciary. He wrote, quote, "If there is a genuine concern about the qualifications about judicial nominees, this is a debate I welcome. But the consistent refusal to move promptly to have that debate or to confirm those nominees with broad bipartisan support does a disservice to the traditions of this body, the Senate, and the American people it serves," unquote. In this new Congress, we will continue to make this case for treating the confirmation of judges as the priority, the urgent priority that it is. We will make this case from today through the end of this session and into the next. And our goal is to do so in a way that simply, sharply defines the issue, seeks to raise the sense of urgency, and calls on the good faith and shared commitment to our system of justice that can be found among Democrats and Republicans alike. For our part in the administration, we continue to devote our energies to removing obstacles and excuses for delay. We have obviously appreciated the process by which nominations are made, presenting challenges of its own. As the citation to the Miller Center report of some years ago reflects, this is nothing new. There are delays in the nominating process, but we are not sanguine about it. Identification of the candidate, consultation with the Congress, coordination with the American Bar Association, and the ever-exacting vetting process consume more time than they should. We have made adjustments. We will make more. But the number of nominations in the last year has been steady, 71 in 2010, an increase of 73% over the 2009 number for a total of 112 overall. And as I noted, some 49 are now before the Senate. The Judiciary Committee hearing schedule, for all intents and purposes, is booked for this purpose until the spring. So it's not for want of nominations that we do not have confirmations. Now, I appreciate, of course, that there are occasions when there are major differences over the jurisprudential outlook that one nominee or the other will bring to his or her post. Very often, these differences are absurdly overstated, and each side to the debate would do well to take up a more measured stance in these discussions. I understand that my wish is unlikely to be granted, but I've learned in this job that one hangs tightly to whatever slim thread of hope one can. But eventually, after full and fair deliberation, a president's nominees must receive a vote. This principle goes to the heart of the advice and consent process, to the president's constitutional authority to nominate and to the Senate's constitutional authority to give or withhold consent. Stepping back from old controversies, eschewing the habitual finger-pointing, originalists and living constitutionalists and all those in between should find common ground in upholding a process, a constitutional process, that moves from nomination to debate to a vote. In this respect, returning to the theme that we should treat nominations and confirmations as if they really matter, one way certainly is to respect constitutional form. The case in which a vote is denied should be rare, truly exceptional in character, and serious rather than casual discussion should be devoted to the question of what such a rare case might be. Now, of course, some senators may fear that committing to an eventual vote will give the game away, removing any serious incentive on the part of the administration to heed concerns and consult about particular nominees. Fair enough. That's essentially a question about good faith. But this administration is committed, and I believe has shown that it will consult with the Senate in good faith. We have endeavored to do this. We have agreed to review a second time, occasionally a third time, the issues raised about a particular nominee. But if in the end the objection is simply that a senator or senators would prefer a different nominee, or would insist on one who would have decided past cases differently on a different reading of the law, then the objection should be put to a vote. Against this background, this is what the administration hopes to accomplish, believes that it can accomplish in the year ahead in close collaboration with congressional leadership. We will work with Democrats and Republicans alike to re-examine seriously where we stand on individual nominations and on the process generally. This has to be a bipartisan process. And I'm convinced through conversations with Republicans as well as Democrats that there is a growing recognition that however we got to this point, over however many years, we cannot in good conscience remain here. I've heard the same from sitting judges, a group including nominees from the Republican and Democratic administrations of the past, and they come in bipartisan groups confidentially to express deep concern that the path at which we have arrived is simply not sustainable. So the principles on which I hope we could reach agreement and believe that we could reach agreement are as follows. Judicial nominations are an undertaking in public administration, the administration of justice, and this is a first principle to which we will always have to repair. The current slow crawl cannot be reconciled with acceptable standards for maintaining our system of justice in good order. The administration will continue to consult closely with senators in full recognition of their legitimate interests and concerns and prerogatives, while expecting that differences about particular nominations can be explored on a common understanding about what constitutes a legitimate, reasonable ground of difference. And last, where legitimate differences remain, and this will affect a small number of nominations, but those differences will remain, the nominee should have a vote anyway. None of these principles should be beyond the reach of good faith agreement and implementation. And at a time when the American public is asking with particular intensity that the parties work together to solve problems, this problem, the problem of our damaged nominations and confirmations process, should not be left out of the bipartisan work to be done, because to refuse or neglect this work would be to affirm, again, that somehow, in some way, it does not matter. And certainly there should be agreement, and I think there is agreement, that that cannot be true, that a process so vital to the administration of justice does matter very much. As the President stated last year, and I quote, The real harm falls on the American people who turn to the courts for justice. All Americans depend on having well-qualified men and women on the bench to resolve important legal matters, from working mothers seeking timely compensation for their employment discrimination claims, to communities hoping for swift punishment for perpetrators of crimes, to small businesses seeking protection from unfair and anti-competitive practices, unquote. And we could obviously multiply many times over the list of the kinds of cases Americans are trying to bring to their courts that, because of this state of affairs, cannot be heard in a timely fashion. So in 2011, the task is urgently to have the performance of the judicial confirmation process at long last rise to the level of its importance. With that, I'm happy to take your questions. Yes?
Yes. As with judicial nominations, U.S. attorney positions have faced some similar difficulties. In particular, in Texas, no U.S. attorney positions have been nominated. Can you discuss briefly the timeline for nominations in these positions and what the state of U.S. attorney nominations is across the country?
Well, obviously, the subject of judicial nominations is a subset of a larger discussion about nominations, executive nominations, and the speed at which the nominations are made and the speed at which eventually they're confirmed. And there is no question that we have experienced across the country, in particular cases, some real difficulties in moving nominations. Some of the problems, I think, that have been at work in those difficulties, I've alluded to in these comments. There is a robust process of congressional consultation, obviously congressional interest in law enforcement and the nominees to law enforcement positions is very intense. And there are often very sharp disagreements that break out about precisely how those positions should be filled, the qualifications of individual candidates to fill them. And that is even after the point at which we find willing candidates who submit to and ultimately emerge from the process by which we review those candidates and vet them. Let me assure you the effort that I'm suggesting that we are making and will continue to make to move judicial nominations will translate also and carry over into nominations to other positions, including the positions that you cited. And we will, and maybe so I move from a level of abstraction to something more specific. I won't mention a particular nominee, but I'll mention an aspect of the process. We will do what it takes to try to break through gridlock over some of these nominations. To give you sort of an idea, we have gone multiple times back to the Congress, sometimes just to the Senate side, sometimes to whole delegations that have a stake in the matter, to revisit in person issues that have been raised about potential nominees. It might be a conflict about who should be nominated. It might be a conflict about a particular proposed nomination. It might be a vetting issue that has to be worked through. But what I want to stress is we're in constant contact on these issues, and sometimes they prove very, very difficult to address. That's not true across the country. It's true in some cases because of some particular conditions, some particular circumstances. But we spend a great deal of time trying to work through that. I want to recognize my Deputy for Nominations, Susan Davies, is here, and I'm sure would attest that we devote a great deal of time, not just on the phone, but in person, in a variety of ways, trying to work through these issues to a resolution. And in a large number of cases, we're successful. In the cases that you cite, we have not so far been successful, but we will continue to work at it. Yes?
Joanne Anderson with Congressional Quarterly. Two questions, if I could. I wonder what, does the renomination of some of the most controversial judicial nominees, such as Goodwin Liu, what, if anything, that says about your thoughts on the prospects of them actually getting through the Senate this go-around? And on an unrelated topic, if you could, any reaction on yesterday's court ruling on the healthcare law?
Very sneaky. Nice little stalking horse question about judicial nominations, and right behind it comes healthcare. The president does not nominate, nor in any case has he renominated any individual the administration does not expect to fully support and to fully bring to a successful confirmation vote. That's true in the individual case you cite, and in the case of all the other renominated judicial prospects from last year. We're fully committed to them all. We will work the process very, very hard. We will speak to individual members where there are concerns, and we will move, as I suggested earlier in my comments, very hard to assure the earliest possible vote with every expectation that we can successfully place all of these individuals on the court. Now, what was your second question? What was your question, actually? Do I have any reaction to the healthcare vote? I would have decided it differently. This is one district court decision. There have been a number of decisions. We've won so far. The administration's position has been sustained in a number. In this case, the administration's position was not sustained. And so this is part of a process, and eventually we'll have a resolution of these issues. I don't think that yesterday's development, other than adding another voice to the, if you will, opposition to the bill, to the constitutional objections to the bill, alters the current course toward resolution, a resolution that I expect to be successful. Yes?
Just a second. Are the problems you've talked about problems about nominations in general, or is there something particularly dysfunctional about judicial and law enforcement nominations? And if it is the latter, is there a reason why?
Well, there are obviously different categories of nominations that are going to attract different levels of interest, in which Congress is going to have different perceived equities. Obviously, congressional equities and nominations are extremely significant, and judicial nominations, by virtue of the lifetime tenure feature and the importance of the caseload that moves through those courts, is going to raise the stakes considerably. There have obviously been issues in the executive nominations process as well, so I think there's some overlap in the character of the difficulty that has affected both these processes. But I definitely think that, you know, by virtue of the lifetime tenure of these federal judges, there is, and the significance, again, of the caseload that they decide, there is a high level, and legitimate high level, of congressional concern to participate actively through the advice and consent process. Now what we need to do, however, is to have that process work more functionally and appropriately, and I think consistent with the constitutional and original expectation. As I said, we should return more to constitutional form here, and at a minimum, expecting that there will be disagreement, have a full and fair deliberation and eventually a vote. But if your question is there something about the judicial nominations, set of nominations generally, I think those are at least some of the features that I would identify. Yes?
Has there been any discussion with Senator Leahy about abandoning the blue slip procedure the way the Republicans did when they were in charge?
Well, I'm obviously, not at liberty to disclose conversations that we have with the chairman of the Judiciary Committee. As I mentioned before, we are of a mind that we should sort of look beyond those battles, and addressing the process as we find it, look for ways to work through to a successful resolution, and that's the course that we're on. And I believe it's completely feasible. As I said earlier, I'm hearing from Republican members as well as Democrats. Republican members have no less of a concern about how this works. And some of them, for all the disagreement that you can expect on these issues, some of them have expressed to me in fairly direct terms that they believe that the system is breaking down, and they have offered to help. And I take what they have offered at face value. I believe, based on my prior working experience with them, that they mean what they offer sincerely. And I believe that there is a bipartisan route, even under the current process, to bringing these confirmations to a successful conclusion. Not just confirmation of the nominations that are already in the pipeline, and as I mentioned, that's quite a thick number, but the nominations still to come. Yes.
You mentioned the problem with access to the courts. At what point does it become a constitutional issue, perhaps allowing for the military courts to open, or some other thing about access?
I thought I put the point fairly dramatically in my prepared remarks. And now you've reduced me to vanilla, and I'm ready to leave. I don't think we need to worry that we're at that point or anywhere close to it. Frankly, I haven't contemplated that as a remedy, and I don't know of any, I'm not terribly worried that you need to be worried about it. Yes?
How useful do you consider the weapon of recess appointments?
I don't know that I would ever have defined it in terms of utility. I think sometimes it's defined in terms of necessity, where a position isn't filled and it does not appear that there is any potential ground for agreement. There's important work in the government that needs to be done. Now, as you can imagine, recess appointments are a quite inadequate response to the problem with the judicial nomination. You're not seeking to make a time-limited appointment. You're seeking to actually confirm in the normal course so a judge can serve for as long as he or she is able. So, again, I view that as a question of necessity, not utility. But there are times in other nomination contexts where it's absolutely indispensable or the work of the government simply cannot be done. And as I mentioned earlier, the question of judicial nominations is a question of public administration. And unfortunately, in recent years, it has become so enmeshed in sort of partisan conflict that it's become more a subset of politics generally than public administration as it should be. There's obviously going to be a political dimension to these debates, but it's still a public administrative issue. There are cases to be decided. Not every one of these nominations is one on which the greatest issues of our day turns. There are Americans every day who have to bring their cases to court and have them resolved. There's ongoing development in the law that competent jurists have to steer in the correct direction. So we have to view this nominations as something we address as part of just what's required for sound government. The same thing being true of executive nominations, which is when it sometimes becomes necessary to make recess appointments if a position is going to go unfilled and the business of government is not going to be done. Yes, back.
I've read much recently about the Senate not giving votes to various unsavory proposals that are enacted or voted out of the House of Representatives, which raises the possibility, of course, of some horse trading in terms of, we'll let you have a vote on this if you let us have a vote on nominees. I'd welcome your comments on that, both from a practical political standpoint and also from a principle standpoint.
I'm sorry, just could you restate the question there? I want to make sure I understood it.
The, apparently the majority leader, Senator Reid, is not going to allow votes on a number of things that the House of Representatives is passing out, trying not to mention a particular subject like health care. So there's a prospect, obviously, of trading, some horse trading. We'll let you have a vote on health care. You give us votes on X number of judicial nominees. And I'd welcome your reaction to that, both as a practical political question and also as a principle question in terms of dealing with judicial nominations.
I'm going to probably disappoint you by staying within my own assigned sphere of responsibility and competence. I'd rather not address the various ways in which business of the Senate is moved. Obviously, the members make judgments about which measures, in which votes, in what combination will be scheduled or taken, and that is a complicated process that I think it's probably best that I not comment on. I think at the end of the day, my view is, and I don't mean this as sort of a vindication of end justifies the means analysis, we have to simply arrive at an understanding, not that we can in a particular circumstance arrive at votes on confirmations, that by some route we manage to get there, but that as an affirmative matter of caring for our judicial system, we have to have those votes. We have to have those confirmations. So those votes may develop in other ways, and I welcome those votes when they occur, but I think the larger point I want to make is this is a matter of urgency right now that goes to the very heart of whether we have a functioning system of justice that we can offer the public of this country. Yes.
I guess I'll be that guy to ask the question. What's the administration's next step with Guantanamo, given the actions that Congress has taken? Have you given up it happening within the next 2-year period?
I think what I'll do, so that I can now decline to answer 2 questions in a row and set a record, is allow Caroline to schedule me to appear at an event dedicated to that purpose. There's a very complicated question. You've asked a question that would require several minutes of explanation and some background, and it's probably more than within the sphere within the assigned topic of the day and the time that we have that we can do. Thank you very much.
Thank you so much, Bob. That was extremely stimulating, interesting, and I'm very eager to hear what our panelists have to say in response. We are fortunate, after Bob's talk, to have 3 exceptionally well-qualified panelists to react to what Bob had to say and to give their insights into how President Obama has fared thus far with judicial nominations and what the road ahead looks like. Macon Delrahim is currently a shareholder in Brownstein Hyatt Farber Schreck. Macon was appointed Deputy Assistant Attorney General for the Department of Justice Antitrust Division by President George W. Bush in July 2003, and from 2000 to 2003, he was the staff director and chief counsel in the Senate Judiciary Committee, working as the principal legal and policy advisor for then-Chairman Orrin Hatch. Carolyn Lamb is a partner at White & Case in the District of Columbia. Carolyn was president of the ABA from 2009 to 2010, as well as a past president of the DC Bar. She was named one of the 50 most influential women in America by the National Law Journal and one of Washington's top 30 lawyers by Washingtonian magazine. Bill Marshall is William Rand Keenan Distinguished Professor of Law at the University of North Carolina School of Law. Bill was Deputy White House Counsel and Deputy Assistant to the President during the Clinton administration and served as Solicitor General of the state of Ohio. Bill has published extensively on the First Amendment, federal courts, and presidential powers, and is a leading expert on judicial selection. And of course, of great importance to the American Constitution Society community, Bill has lent his great expertise, camaraderie, and guidance to ACS as a member of our board. So now I guess we will hear first from Macon, then Carolyn and Bill, and their reactions to Bob Bauer's remarks, and then we'll have a little conversation about what that means for the state of our judiciary. Macon?
Thanks, Carolyn. And first, let me just thank you for inviting me to be here. It's on this, I think, one of the more important topics that we can discuss in a democracy. As a lot of us have been watching what's been unfolding in the Middle East and Egypt and this morning in Jordan, it reminds me, I was 10 years old when I left Iran, and it eerily reminds me of exactly what was going on back then. And not really appreciating it back then, I really think, in my experience, having lived in the government and having had the opportunity and the honor to work in all 3 branches of the government, I think that what we have in America as far as the judicial branch, an independent judicial branch, is, in my view, probably the most significant element of a true functioning democracy. People can take their grievances to the courts and be comfortable that they will most likely, regardless of what the outcome is, and people will be happy and unhappy half the time with the outcome of whatever the grievance is. But we respect that, whether that is on an issue of health care, whether it's an issue of intellectual property, whether it's an issue on the election of a United States president. We don't go to the streets and riot. We'll hold peaceful demonstrations. But generally, we respect, 4 Supreme Court decisions, whether it's on racial issues. And that is probably the most calming influence in a democracy. So this topic is incredibly important and very personal to me. I was, glad to hear Bob's comments about not really rehashing past statistics, because I think both sides can get into statistical jiu-jitsu if they wanted to and get back and rehash grievances back to the 80s of who has left more vacancies, who didn't process. The one thing that is, I wanted to stress, though, is that, Bob said there is this pattern, an alarming, a profound change that we're witnessing here. And there are 99, I believe, or, these things change on a day-to-day basis, about approximately 100 vacancies now, 49 nominations for those vacancies. So more than half of those vacancies do not have a nomination associated with them from the White House. President Obama's nominations, 60 of them got confirmed last year. At the end of the year, where there were 99, at the end of the first two-year Congress, 99 vacancies, 58% of those did not have a nomination associated with them. So I am glad that the White House is finally making nominations a priority, but they had other priorities to which they addressed their attention: healthcare, financial services reform, energy, and other matters, as well as the financial crisis that the president has been dealing with. So nominations, I don't think folks can say, regardless of what side of the aisle you come from, has been a priority for this White House until now, and maybe now it will become one. But I can tell you one thing: it is not a partisan issue, that either the delay or the confirmation of President Obama's nominations. A couple of statistics that I will mention, just facts to look up, as Bob said, is that President Obama's circuit court nominees, from the time they were nominated to the time they got hearings, took them on average 64 days. President Bush, from the time they were nominated to the time they got a Judiciary Committee hearing, 247 days. 64, 247. District court nominees of President Obama waited 60 days to get a hearing. District court nominees for President Bush had to wait 120 days before they got a hearing. Now, if you know the Senate rules and the process of the confirmation, there really is no impediment to the Democratic majority to bring a nomination for a vote or hold a hearing. As soon as the White House nominates, there is no impediment to Senator Leahy holding a hearing for that nomination, and no impediment to Senate Majority Leader. Bob said that there was a single senator can freeze all nominations. Single senator can withhold giving his unanimous consent, which is what's asked. There is nothing to stop Senator Reid, as the Majority Leader, to go to the floor and bring up that nomination to be considered and debate. If there's a senator who's not willing to give their consent, as is their constitutional prerogative, nothing for him to say, no, we're going to debate this and move to it, or if he wants to, just like he's done in other areas of legislation, if the nomination is important enough to him, get 16 senators to sign, hopefully you can have 16 senators who would support the nomination, to sign a cloture petition and file it immediately and move to getting that nomination up for a vote. This hasn't been an issue given other priorities of the Democratic Party, but certainly the Republicans have been in no position to block either a hearing or actually taking it to a vote in those last 2 years. So, I am glad that, that it is becoming a priority, and hopefully, the consultation and all that process will go. The one thing that does bother me, though, is a couple of nominees who, when the Democrats had 59 senators, actually for a period of time, they had 60 senators when Senator Specter switched parties. They couldn't get those nominees up, or they didn't think it was important enough to bring those up at that time. When they had 59 for, after Senator Brown won in Massachusetts, they couldn't find a single Republican, presumably, to support one of those nominees, to bring it up for a cloture and go for a vote. I think when you have only 53 Democratic senators and a number of them coming from, difficult red states, it will become a heck of a lot more difficult. So why renominate? Why not move forward, work with the senators in a bipartisan manner, and send nominees that could get the support, unless you're looking for just a fight? Because that is going to be wasted time that is going to be spent on those couple of nominees that are not going to get 60 votes to bring them to a final vote, that could be used on other nominees that could find consensus to bring it. My views on filibustering nominees is public, and at the last ACS event, I've taken a different position than some of my Democratic colleagues. I actually think there should be a change for filibustering judicial nominees and changing the rules, but not, I think it's that to have been fairly done, you have to have a number of leaders come together and say, for the next president, whoever that is, or for the next Congress, whoever is going to be in charge of either the Senate or the presidency. And that's where, some leadership needs to come together to make that change. Otherwise, within the current system, if there has been fewer nominations confirmed than the White House would have liked, I think it only has two people to blame, the White House and the Democratic majority in the Senate.
Thank you, Macon. I think you've given us lots to talk about, so I'll turn it over to Carolyn.
Clear views. Well, it's a pleasure to be here and talk with you today, and I have some observations that I want to share about the real impact of these vacancies on the public and on the lawyers who have to appear in front of judges who are overworked and unable. And it has profound implications, as I think Macon and I both agree on, with respect to our system of justice, with respect to the due process that's afforded people and their ability to have their rights heard. And it is simply something that we as Americans and we as lawyers cannot tolerate. And I want to give you some, for instances, in terms of the impact of the vacancies, and I'll talk a little bit then about the why, which Macon certainly gave a perspective on, and some recommendations for what we can do about it, and urge both the Senate and the White House to do their jobs and get our benches full to the place that they should be. First, let's look at when we're talking about judicial vacancies, it's not detached from reality. They have the judges in those districts where they are not fully staffed, have staggering caseloads. They are strained beyond capacity to deal with those caseloads, and they're unable to keep up with them. And what that translates into in the day-to-day world for lawyers who appear before them, for litigants who appear before them, is they have to delay civil trial dockets, and they take Speedy Trial Act cases first. So that means if a litigant is in there with a personal injury, with a contract dispute, with a constitutional dispute, they're not going to be heard until Speedy Trial Act cases are dealt with. That means the criminal cases are dealt with. Indeed, in Arizona, after Judge Roll's murder, the district court declared a state of emergency and has, in fact, extended the limits under the Speedy Trial Act, so that the accused now has to have a hearing in 180 days for the next 12 months instead of the mandated 70 days. Now, that's really reprehensible in our system. It cannot be tolerated. They have already, in an extremely busy district, 3 vacancies, and they are not full. And I'm not going to be judgmental about who caused the 3 and who should be getting them through. It is urgent that we move people through and get people on the bench. And we simply cannot say, well, they should have gotten people together to, invoke cloture or not, filibustered or whatever. We need to move it. Senators have to do their job under the Constitution, and senators are not doing their job under the Constitution. The judges also in these districts adopt efficiency measures. And what that does is impact due process. It cuts back in the name of efficiency because they don't have the time to devote to cases. It cuts back on how much time they're going to give to a litigant to present their case, how long the pleadings will be in front of them. And that really alters the quality of justice. Another thing that it results in is in these overburdened districts, we find judges resigning. They don't want to deal with justice in that way. We find judges retiring. And we also find excellent attorneys deterred from accepting a nomination. It shrinks the pool. Now, we heard, if we focus on why is this going on, we heard, of course, that, with respect to the rate of nominations, that the president has been slow. In the first, part of the Congress, of course, the pace was slow. But when we look at the record, I'm not sure that the record demonstrates that that is the contributing factor. The Senate postponed voting on 22 nominees until the lame duck session. They never considered 19 pending nominees. These are people that are reported out of committee. The worst vote out of committee was 12-7, and that was only on a few. Most of them come out of the committee with unanimous approvals. And then they sit in the Senate without action. 13 of those 19 pending at the time of adjournment, in fact, came out of the committee without dissent. There was no controversy. No Republican senator questioned their qualifications. And 13 of the 19 were on the list of 49 judicial emergency districts. That's truly an abdication of responsibility that can't be tolerated. Now, I do think the administration should be increasing the number of pending nominations to increase the pressure, to be sure. And we should do whatever we can to encourage the administration to do it. But that said, they have to move out of committee onto the floor and get a vote. If you look at the rate of confirmations, the Senate, in fact, has been using dilatory tactics, blue slips. One senator doesn't return the slip, and there's no vote. It just sits. And we find the Senate did, in fact, confirm 62 nominees. Dozens of nominees never got to the floor for consideration that had been reported out of the committee without any dissent. 2/3 of the nominees presented to the Senate were reported out of the committee without dissent, and yet were subjected to delays on the floor. And then those that did get through generally got through with unanimous vote or almost unanimous vote. So there wasn't any great dissension about the qualifications of those nominees. To be sure, I think there is on maybe 6 nominees, but the remainder are getting through and without any great dissension in terms of who they are and why they should be going through. We do understand, as Mr. Bauer indicated, that now there are, in fact, some discussions going on to change the procedures, and we applaud that. It must be done, but it must be done yesterday. They really must come to terms in terms of filibuster, in terms of voting on the floor, and move the process. To avert any kind of a potential crisis and to preserve the quality of our judiciary, the ABA urges, and we've urged in letters, we've urged in resolutions, we've urged directly, that both the Senate and the President must make the prompt filling of judicial vacancies a priority. The administration has to make a concerted effort between the time that a vacancy is announced and the time that a nomination is made. And the Senate has to give every nominee an up or down vote within a reasonable time after the nomination is reported out of the Senate Judiciary Committee. Now, Macon mentioned there were many, and the time was quite short, that got a hearing right away. The real time where there's been a problem is between reporting out of committee and getting a vote in the Senate. That's the problem. That's where we're seeing a lot of antics. It's not necessarily just getting a time in front of the committee. And so I guess in terms of the prognosis for the future, it's very encouraging that both sides of the aisle recognize now, and we've heard from both sides, that the system isn't functioning efficiently or effectively, and that they are both considering changes to the process, even though we've heard that filibuster may remain an option. But we applaud their efforts. We certainly applaud the Chief Justice coming out as strongly as he did in his year-end report to focus the attention on these very serious issues, and his imploring both benches to perform their constitutional duties. We regret that the Senate Judiciary Committee, on the first batch of nominees that were to come out last Thursday, were delayed. And so there still remains work to be done. And certainly, I think Macon is exactly right on the point of the impact of this on the people. Not to be ignored is what goes on in the streets in Cairo and Tunisia. And you're quite right, I think, that what distinguishes us is our judicial system and people's assurance that they, in fact, have a day in court and can have their grievances heard. And the fundamental right to justice is at the core of preserving our democracy, and at the core of that is a competent judiciary. And we're not going to get there, and we're going to have litigants and all kinds of litigants, criminal and civil, tremendously frustrated and not tolerating the kind of delay and indeed denial of justice as a result of a lack of a fully complemented bench. So there can be no higher priority. This must be something that the public and the American legal profession insist be at the top of the agenda, and that both the senators and the administration perform what are their constitutional duties.
I thought it really interesting when Bob Bauer started off his comments to talk about the good old days under the Bill Clinton judicial nominees and the good old days on the George W. Bush judicial nominees, because as I recall, neither one of those were good old days. The situation's been bad, it's getting worse, and unless we turn it around, it's even going to get worse than it already has been. And I think what we've seen is that every opposing group to whichever president is in power has escalated the tactics being used to oppose judicial nominees, and we've gotten to a point of complete absurdity at this point where delays are taking place even with respect to judges who, when they get a floor vote, as just was mentioned, will go through unanimously or pretty close to unanimously. This is a new way of slowing things down. You keep things down up until the last floor vote, and then you look bipartisan because at the end of the day, you finally make your vote. I'm going to get back to the problem with that in a moment, but I want to, again, reemphasize the harms that this is causing. One, obviously, we've talked about is the harm to litigants. The second we've talked about, and Chief Justice Roberts has raised, is the harm to the American justice system, which is one of the pinnacle parts of our nation's democracy. And the third is the harm to the nominees, which we haven't talked about all that much. But if you're a lawyer and you've been appointed to become a judge, you can't take cases in the same way that you could before. Your life is put on hold. And what this is doing, obviously, is discouraging good people from letting their names being entered into nomination, because you can come before the White House if they reach out to you and suggest, would you like to be interested in this job? And they can say, you've got nothing uncontroversial in your record. And you can look at them and say, well, does this mean I'm going to go through quickly? And the answer is still no. One of the problems that both Democrats and Republicans have agreed about, except when they're not in power, is that the system that we have is discouraging good nominees to come forward if they have anything controversial in their record. Now you don't even have to have anything controversial in your record and have a major disincentive to coming forward because of the tactics being used to stop even non-controversial nominees from going through. Now, why is this happening? What has caused this? And a part of it has been mentioned, is that the Democrats have not put as much emphasis on this as they should have in the early parts of the administration. Point taken. But why has it really occurred other than that? I mean, to listen to Megan, if only Harry Reid just put the names out there, they would have been confirmed like that. What a beautiful world. Except, of course, they were putting holes on everybody and threatening filibusters to everything, and then Megan says, oh, what a beautiful world. You just do motion for cloture and the filibuster, and you get rid of the filibuster, and you get to your unanimous vote. Except that takes 5 days. And to take 5 days for every nominee going for the district court is going to slow the process down into nothing. That was the threat. Senator McConnell has taken great pride on his 2-year strategy of delaying everything so that the White House couldn't get traction on anything. And he's paid no political price for that in judicial nominees. In fact, he's reaped great benefit. But this is just part of that strategy of slowing everything down, making everything a hard lift, so that the administration can't get anything accomplished. And I understand the tactics. And certainly, if you ask most Republican senators, they're going to tell you they were very effective tactics. The problem, however, besides discouraging good and qualified people from coming forward, is that the problem is there's very little capital being expended in opposing a judicial nomination, particularly when you do so quietly, particularly when the only threat is you're going to have a filibuster maybe, and then at the end of the day you actually vote, so you can go back and say, well, I was bipartisan. So there's no real political capital that was expended by those in opposition during this period because people don't think about judges and the nomination of judges as important as they should for all the reasons that we've talked about earlier. So this was a very low expenditure of capital, I'm sure the Republicans thought during this period. The problem that they really missed, though, and I think what we really need to focus on here, is that we're not talking about the Democratic administration's capital. We're talking about the capital of the American justice system. And that is the capital that is being squandered by this kind of mindless opposition to delay just for the sake of delaying. I have to end on Megan's other final point of, boy, what a great thing if only President Obama dropped the 6 nominees who've had any controversy whatsoever, then we could go forward nice and easily. So basically what I think that means is that the Democratic administration should only nominate judges who will get unanimous consent, so that if any Republican opposes or 2 or 3 Republican opposes, then we should pull back, and the Democratic administration should pull back pull back their nominations. I'll be interested to see if that's the tactic that's taken by the next Republican president. It certainly wasn't the tactic taken by the last Republican president, who put up some of the most ideologically driven nominees in our nation's history. And I'm not sure why it occurred now. I mean, the real problem, as I can see it, as some see it, is that President Obama hasn't put up enough nominees who would be controversial in any sense. And when I use the term controversial, I don't mean outside the mainstream. A criticism from Jim DeMint is not outside the mainstream. And I think that has to be remembered as well. But even if we can't, even if we want to put aside this constant debate we have about who's outside the mainstream and who isn't, let's just go back to the holding up on the non-controversial nominees for a moment and think about what a game and what a facade has been played to the detriment of the American political system. And yes, Megan, I will blame Harry Reid in part for not being aggressive enough on this, although he did have some other priorities. I do think that in the early parts of the administration, President Obama could have been more made this a greater priority at that point, although clearly he had a major recession and facing a major recession on his mind. But I think I'm going to put Senator McConnell at the top of the list.
Well, this has gotten spicy. Which is what we wanted. I'm sure Macon will want to respond to a variety of points, but and I'd have to confess, Macon and I were both in the Senate during the battles under George Bush, and I worked for Tom Daschle before that. We had other battles when Bill was in the White House counsel's office, and so we've all been part of this sort of general give and take, to put it nicely, for quite some period of time, and so I know I take seriously what Bob said about not rehashing the litany of complaints, so that we could all go through our own versions of them. So I'm thinking, and again, I don't want to deny Macon his opportunity to answer some of the points that have been made, but I would like to ask, as a general question that I hope you'll also address in your conversation with each other. But we've all acknowledged that the system is broken. We've all acknowledged that there has been, from whoever is to blame, I think the Washington Post called it at the beginning of the Bush administration, the politics of tit for tat. And so we've had the politics of tit for tat for quite some period of time, and we acknowledge that there's a significant problem now, high judicial vacancy rate, emergencies, the impact on the American public. So what should we do? How do we actually lift this logjam? Are there solutions? I open that to anybody to respond to. So I'd start with the hardest question first.
Well, there have to be. We really have to work together. When I left the White House counsel's office, I felt that some of the slots that were still open were open unfairly, that they should have been confirmations on various people, one of which being, of course, Elena Kagan. But I wrote some letters in support of Republican nominees who were up for nomination. I mean, I think there has to be some bipartisan work. I think, and we've seen Goodwin Liu has gotten a number of strong support from Republicans, and I think that people have to try to make this a little bit more of a bipartisan process than it is, and to not carry the grudges of the previous administration forward to the next one. But also, I mean, even if we stayed at the level of grudge that existed at the end of the Bush administration, we've taken this to a new level. And we've taken it to a new level that is really pulverizing when you start making this kind of delays with respect to people who ultimately turn out to be completely non-controversial.
Carolyn?
I do think, and it's one of the points that you made, there has to be a price to be paid for doing this, whether it's the Republicans for holding it up or the Democrats for not pushing it through. Whatever it is, I think there has to be some accountability because it's such a fundamental and serious issue. And in part, I think the press needs to get the word out to the states and to the districts that this is what's going on. I think most people don't understand. They don't know the impact that it has. They don't know what kind of brinksmanship is going on in Washington that's impacting their daily lives. And I also think the state bars, who do have some resonance with the senators, whether they're Republican or Democrat, because they are all opinion leaders, need to speak out very strongly and forcefully in those districts where we find that, in fact, we aren't getting people through and on the bench, and that's prior to the price to be paid to let the senators know that indeed the lawyers are watching and the public is watching.
Macon, you get your turn here.
Well, it's just fascinating. Letting the local press or the state bars and all of that know what? That when asked before a nominee is brought up for a unanimous consent, that a senator is saying, no, I'd like to have my 2 cents about this nominee because I didn't sit on the Judiciary Committee. I'd like to have a real debate about this. And look, it would take literally 30 hours when dual track with legislation. Let me equate that to something that you're saying with nominees, with legislation. Let's assume that Senator Reid is holding on something like health care reform. And he's saying, I have this bill, which I'm not bringing up to the Senate for debate or voting, but I ask unanimous consent that it be passed. And if any senator opposes it and does not give unanimous consent, you're saying they should be outed or they're doing something egregious. No, these are the Senate's rules. These are the Senate's rules. They have been, unless the rules are changed. We have to respect that. The fact that a senator, I want to state this clearly, the fact that a senator is not giving unanimous consent does not mean that they're somehow doing something nefarious or obstructing, because they're saying, look, give me the vote. Of those 19 nominees that didn't get a vote at the end of the year, 15 of those 19 were reported out of the Judiciary Committee in December. 19 got confirmed in a lame duck. You have to go back to 2002 to actually find lame duck confirmations. So I think, Senator McConnell should be commended for even allowing that to move forward. For those were unanimous, and they allowed them to go forward. Those nominees, I think there's legitimate debate about Goodwin Liu and his views. And this is actually a healthy debate in our democracy. These are lifetime appointments. These are judges that affect every one of our rights. You saw yesterday with health care, maybe half the country or 40% of the country really supports this. There's probably, 40, 50% of the country that strongly opposes it. And our constitutional rights are decided by these judges. Very important positions. So his views on Constitution, his views that are, all over the record, are very legitimate issues for debate. If not a single senator on the Republican side could have been convinced by this White House, when this White House had 59 Democratic senators, then there is something wrong about that nominee. Or bring it up and debate it. Let's see what that is. That's a healthy debate to have about that person's views on the Constitution. So, I appreciate what Bill was saying and saying, oh, Macon says, yes, Harry Reid brings it up and they go through unanimous consent. That's not what I'm saying. I'm saying, I'm not saying also what you mentioned is that only nominees that can get through unanimously should be nominated. No, they should at least have 60 votes under the current rules, not 160. And if you have 59 Democratic senators, find one Republican, not a consensus, between some of the senators who have voted for health care or the stimulus and other those. You can find at least one senator. If you can't on that particular nominee, then there's an issue, or at least debate it. If you believe strongly in it. We wanted to do that, for example, with a nominee like Miguel Estrada. He was not allowed. I mean, this senator, this current president, when he was a senator, voted against, nominees that flew through, against bringing him up even closer. So do we, was he also part of this? He held very strong views. He gave some strong speeches of why he's voting to not allow cloture and a debate on some of these nominees like Alito and Roberts. The other thing, I think, just one last thing to mention is, look, this president had, during the time, 2 Supreme Court justices nominated and confirmed. Those take a lot of time and resources of the Judiciary Committee. So I don't think, either Senator Reid or the committee should be blamed. They got through 2, and, very possible that this summer we'll have another vacancy that this president will get to fill. And these are important considerations given the overall numbers of how many get confirmed or how many don't. But just because a senator does not give unanimous consent doesn't mean that they're delaying a particular nominee.
Well, and this, if I could just follow up on Macon's statement, and again, another question for the group, and maybe Carolyn will react to this. It does seem that you're somewhat conflating circuit court and district court nominees, and that at least if you look at under the Bush administration, and I did promise I wasn't going to bring up the litany of complaints, but that the district court nominees were processed fairly quickly, and they weren't required to have 60 votes. They were often not even required to have a vote. And so I don't know if that's something that Bill or Carolyn, that it strikes you as a difference, or is there some different qualification or process that we should have in circuit courts versus district courts, or is...
The Constitution doesn't distinguish, and no one attempts to deny a senator the right to oppose. Indeed, that's their prerogative under the Constitution. But what we suggest is it must be done in a very limited time. And your 5-day limit, that'd be great. A 10-day limit, any kind of a limit. You either oppose and get them out to a vote or not in a certain amount of time.
Well, we are have a fairly short period of time left, so I'd like to ask one more question of the panel and then open it up to questions. Bob brought up something that I thought was a very interesting point, and I wonder if you all could comment on it. He had a list of principles that he laid out in terms of one recognizing that the judiciary, the question about judicial nominations is an issue of public administration. It's something that it's another branch of the third branch of our government, and it's important, and we can't live with the delays that we have. That there is a close consultation process with senators, including having a conversation about what are legitimate differences. And then he said, but even where there are legitimate differences, there should be a vote. And so I guess I'd go back to the legitimate differences and ask, what, I mean, Bill, you mentioned, sort of what is the mainstream, and I mean, is that in this idea of maybe is there a way forward from here? Is there a process that can, in addition to Macon's shortened time frame, I mean, is there a way of actually establishing those boundaries?
Coming up with a standard of what's in the mainstream, so he excludes on the left and who gets excluded on the right, I think would be very hard to do. But I do think it would be helpful if both sides got together and started talking a little bit more about this, so that maybe they can. I mean, I certainly think if there's a Republican president, that the Republican president ought to get a heck of a lot of deference as to who he's going to nominate. I don't think that I would expect the Republican president to nominate the same kind of people that a Democratic president would, and I'm sure nobody on the Republican side thinks that President Obama should be nominating the kinds of people a Republican president would nominate. So everybody recognizes there's a little bit of a spectrum move on both sides depending on who's the president. But I do think it would be helpful if both sides got together and try to figure it out what it meant to be on the fringe on either the right or the left. And that, one of the problems that we didn't talk about today that we really should have talked about today, and maybe it's not the Republicans in the House and the Senate who are at fault, or the Democratic president or Republican president or the Democrat Congress. The interest groups in this town have too much influence over the process. The interest groups on both sides demonize people who shouldn't be demonized and put a heck of a lot of pressure on the people on their party to not let people go forward who otherwise probably should go forward. And maybe if we got a number of interest groups together to try to work things out, maybe we can have a little bit more responsibility from them, because I think that's a little bit needed as well.
No, I must say, though, in the thought of defining what's not right on the right or the left or whatever in some kind of a non-objective approach troubles me. When you're talking about lifetime appointments, I mean, I think none of us could have, on the basis of prior behavior, predicted precisely how Justice O'Connor might have decided some cases, how Justice Souter might have decided some cases, how Justice Kennedy decides cases. Many times people within themselves make decisions when they're on the bench with a lifetime appointment that one might not have predicted. And I would hate to have seen any of them excluded because they fell on the wrong side of a bar.
I agree wholeheartedly with Bill that a lot of outside interest groups really, get into character assassination of nominees. And that is part of the problem that gets into why a lot of very qualified people have no interest in, that along with judicial pay. which I think is something that also should be addressed by Congress at some point, is you don't get the best and the brightest to go through or to want to be considered. And so that's an issue. But the character assassination, racial overtones in some of the nominees is just unnecessary and destructive to the process. The one thing about what Bob mentioned, having that dialogue and having the consultation, that's the most important thing with the Senate. And somebody mentioned the blue slip and these arcane issues. One thing we got to recognize is that the Senate, they're not just a bunch of herds and numbers who follow whoever's in the White House. The Senate is its own entity, and each single senator is a committee of themselves. Lots of the biggest fights between the Senate and the White House, and perhaps some of why some nominees have not been named by this White House, is because it's between the party itself. The senator from home state, who happens to be a Democrat, wants a certain nominee. The White House wants a different nominee, and you get into those fights. That happens between Republicans and Democrats, but the Senate is its own entity. The blue slip functions as a cartel agreement amongst 100. This has nothing to do with partisanship. It's an agreement amongst themselves that they will honor a rule that if a home state senator does not give the A-OK to the White House's nominee, then the Judiciary Committee does not move forward, which is why both parties have honored that ever since Senators Kennedy and Thurmond had put that in place some years ago. But those are issues that is very particular to the Senate. It's those, the prerogatives that the Senate takes for itself, and it's not something that is one way or the other partisan.
Great. Well, we have time for a couple of questions from the audience. I'm sure there are a lot of things that people want to ask about. In the back. Please wait for the microphone.
Hi, thanks very much for, is it on? Okay. Oh, sorry, I thought you were going to give it to me. I have experienced a lot of delays in various courts because of discovery disputes, and people get extensions, and that's a normal course of events when people are getting, they're all kinds of discovery delays and motions to compel and things that perpetuate delays intrinsically in a case, right? So I'm wondering if anybody's done a study with respect to delays being a function of things internal naturally to a case progress, or delays caused by the lack of staff as a first point. And secondly, because a lot of that is remediable by diverting things to either magistrates or do we need the same confirmation process with respect to magistrates, and is it the same? It's my one question. And then, is it possible, if I'm thinking outside the box, structurally, to get these outside arbitration groups like AAA, the American Arbitration Society, the JAMS, all those arbitration mediation groups, looped in somehow to be paid somehow by the courts for those civil litigants not in the criminal part that you mentioned, who want to opt for a mediation but don't want to pay for it themselves, but a mediation that's not a magistrate-driven mediation, but a mediation through one of these other groups. Is there some way to divert some of those cases so that they could see resolution quicker than, a 3-year-out trial date?
I know, Carolyn, you may be the best equipped to answer this one.
There is court annexed arbitration and court annexed mediation. It takes both sides agreeing. And if they don't agree, unless it's in some way mandated by the court, both mediation and arbitration are consensual jurisdiction. There's no way that someone can impose it upon them. I mean, obviously, if it's offered as an option and one person wants to get their dispute resolved and is willing to agree, the other party to drag it out, just as they might do with discovery, will refuse. There are certain situations where it is mandated, attorney fee disputes or something. But other than that, the courts generally don't require it. It is an option. I think both in the report for the additional judges bill, and I was just looking for the number of the bill, but in that report they do identify, in fact, some of the studies that have been done on the impact of a shortage of authorized judicial positions. And I think the Administrative Office of U.S. Courts as well, if you go on their website and look at how they determined where the judicial emergencies are, there are some good statistics on the impact of the delay as a result of not getting the judge to hear the case, and the kind of creative approaches the judges have taken, the impact of that on due process or efficient consideration. So there are some things, some studies around. I imagine if you check the website as well of the various U.S. courts and Counsel on Justice, you'll find quite a bit of statistical research.
Are there any other questions? Yes, Jim.
Let's test out this proposition that we can reach a bipartisan consensus. Maybe Bill and Carolyn on the one side and Macon on the other side. I mean, Bill and Caroline, and Carolyn being a Robertsian umpire. Several of you have mentioned the fact that there used to be more comedy. People used to talk to one another. Actually, people used to vote with the other side's nominees or against the other side's nominees. The difference now is that we have the parties moving frequently in lockstep. So as procedural possibility number one, what would you think of having a secret ballot on cloture votes for judicial nominations so that people could vote against their party without anybody else knowing it? And secondly, you've all mentioned the fact that the problem here is that these are life appointments, which in the case of some of these young people in their 30s who are getting nominations are going to be on the court for a long time. Agree on a practice that the last 2 years of a president's term, he or she only nominate people over 55, and the last year, he or she nominate only people over 65, so that they're not on the court so long.
Thanks, Jim. Bill?
Death panels? With respect to the first part of your question, I don't think inserting more secrecy into the system is a good idea. There's too much secrecy in the system already. There's too little political capital being paid because you can end up with a vote again that you vote for the person in the end, but you've done every dilatory tactic imaginable to stop that from taking place. And again, I want to emphasize, if I didn't do it earlier, I think a lot of the dilatory tactics have nothing to do with the nominees. It's all about stopping the rest of an administration's agenda. Sometimes it does. There's no doubt that sometimes it does, but I think what we're seeing is less and less for that to be the case. And I think again, I agree with Megan, let's have a good dialogue on nominees who do turn out to be controversial, but let's not delay people who are even non-controversial for the mere sake of delay, and I think there's too much of that going on.
I was just going to add that I think actually there were very few cloture votes on judicial nominees, and when there were, they were, as Carolyn already mentioned, they actually had sometimes almost unanimous votes in their favor. And so there wasn't, actually, I don't think once they were forced to vote, people were embarrassed about voting with or against their party. They just weren't really forced to vote. But I think we've run out of time. So I want to thank our panelists, and probably especially Macon for providing us with the counterpoint. So please give them a hand.